Okay, we're going to get started now. So if everyone can just grab a seat. Everyone can just grab a seat. Thank you. Honored guests, ladies and gentlemen, members of the media, begin, welcome, et bienvenue to the public release of the report of the Independent Street Checks Review. My name is Danielle Dowdy, and for the last 18 months, I've served as the Senior Strategic Initiative Lead to the reviewer, the Honorable Justice Michael H. Tulloch. Today, I will serve as the facilitator for this event. So please allow me to just briefly go over the agenda. We're going to begin with a presentation from Justice Tulloch on his report, and following that, Justice Tulloch will depart, and I'll call on the stage our review counsel, and then I will be facilitating questions from the media, question and answers from the media and from the audience, and then that will conclude our event. So, without further delay, please welcome the Independent Street Checks Reviewer to the stage, the Honorable Justice Michael H. Tulloch.
Good morning, and okay, so I would like to first acknowledge that we're gathered upon the traditional territories in Meeting Place for several Indigenous nations, including the Anishinaabe, the Haudenosaunee, Huron-Wendat, and the Mississaugas of New Credit. The territory was the subject of the Dish and One Spoon, One Punt Belt Covenant and Agreement between the Anishinaabe and the Haudenosaunee and allied nations to share in peace and care for the land of this Great Lakes region. Today, the Meeting Place of Toronto is still home to many Indigenous people from across Turtle Island, and we're grateful to have the opportunity to work in the community of this territory. I want to thank you for coming to hear me speak about the report that I've just recently released. Street checks, the police, and the communities they serve are inextricably tied. This connection is underscored in the Pelian principles of law and law enforcement, which recognize that the role of police is to maintain at all times the trust of the communities that they serve. The Pelian principles is one of the guiding principles of the review that I've just completed. And according to Peel, the relationship with the public and the police gives reality to the historic tradition that the police are the public and that the public are the police. Now, at its core, modern policing is founded on public trust. To be relevant, responsive, and meaningful in today's society, it is critical that the police keep the protection and promotion of the public trust as a guiding principle in their work. Because at the end of the day, a community that trusts the police confides in the police. A community that trusts the police helps the police. And a community that trusts the police respects the police. In my remarks, I will first explore the mandate, background, and approach of the Independent Street Checks Review. I will then outline the analysis and key recommendations contained in my report under the following thematic headings. Key definitions and legal framework. When the regulation applies, street checks and violent crime, the banning of carding, duties of police officers and standardization, training and education, retention of identifying information in databases, and overarching changes to improve the implementation of the regulation. I will preface my comments by stating that I feel privileged to be a Canadian citizen and to live in Ontario. Global News recently reported that for the third year in a row, Canada has been ranked as the second best country in the world according to the U.S. News and Report's Best Country list. Personally, I would rank Canada first, but I might be a little bit biased. Virtually all similar reports list Canada as being within the top 10 safest countries of the world. And the 2018 Gallup survey lists Canada as being tied for the country with the highest level of confidence in the police. There's no other country that I would prefer to live in. We as Canadians, we are the envy of the world. We're not perfect, but we live in a country that is better to live in than most other countries in the world. Why is this? This is because of our shared values as Canadians. Regardless of our color, ethnicity, socioeconomic backgrounds, ethnic, gender, sexual orientation, or religion, most of us are hardworking, law-abiding citizens. Most of us want the best for our families, our children, and our communities. So I'll have this guy arrested. Anyway, it's okay. By the way, he's taken some really bad pictures of me, right? So anyway, it's okay. I'll excuse you. Just make sure that the pictures are good. But, okay, so over the course of this review, I've had the opportunity to travel throughout the province. I met with First Nations, as well as Canadians from all walks of life and racial backgrounds. I learned that regardless of where we live, we all want to feel safe, and we all want to have pride in our communities. We do not want to be stigmatized as criminals or victimized by criminals. We all share these common values. All Canadians want to feel safe in their communities. And most reasonable people understand that we can't feel safe if we don't have a professional police service working with the community to ensure the safety of the community. There are criminal elements in all communities, but no community wants to be defined by the criminal elements that prey on those communities. Most reasonable people that most reasonable people are of the view that in order to maintain safety in their communities, they need to have community police cooperation. Wisdom tells us we can't have community police cooperation without mutual trust. Now, in Canada, we're governed and protected by the rule of law. I have dedicated my life to upholding that rule of law. I understand that police officers share that commitment. I have tremendous respect for police services in Ontario and the work that they do. I've seen firsthand the high level of professionalism of Canadian police services, and in particular, Ontario police services. Police services in Canada and in Ontario have striven to set the standard for policing. They have been willing to try new policing techniques and have been equally willing to recognize when a mistake has been made and that a new direction is required. The people of Ontario should be proud of their police services. While conducting this review, I heard during my consultations and through our civilian survey that citizens generally are supportive of the police. Now, I would like to turn to my mandate, background, and approach. On June the 7th, 2017, I was appointed by the provincial government to lead a full and independent review of Ontario Regulation 5816, which outlines Ontario's new rules on police street checks, a practice sometimes referred to as carding. This regulation is the first piece of legislation in Canada dealing with street checks. Briefly, the regulation applies if a police officer asks a person to identify themselves when looking into suspicious activities or investigating general criminal activity in the community. It also applies where a police officer asks a person to identify themselves for general intelligence gathering purposes. By contrast, the regulation does not apply if the police officer is talking to a driver during a traffic stop, arresting someone, or investigating a specific crime. The regulation outlines what an officer must do if they ask for a person's identification. The regulation also addresses the storage of information that comes from street checks, mandatory training for all police officers on the new rules, and public reporting requirements. I reviewed the content of the regulation and assessed whether police officers, chiefs of police, and police services boards are following it. I also assessed whether the regulation reflects the important goal of ensuring that public police interactions are consistent, bias-free, and done in a way that promotes public confidence and protects human rights. To be candid, prior to conducting the street checks review, I knew very little about the mechanics of street checks or the benefits that street checks may or may not provide to police services, or the impact that street checks may have on those who are stopped by police. To be completely forthcoming, before the review, I was not entirely sure that what even constituted a street check. During the course of the review, I found that my ignorance of these issues was widely shared. As we read the media, as we hear pundits, we hear a lot of definitions of what street checks are. As a result, I had to engage in an intense study of the issues and interact with both police services and community members, as well as members of racial and Indigenous communities who had been adversely affected by the practice. I met with representatives of 34 police services throughout Ontario, held 12 public consultations, undertook a range of private stakeholder meetings, met with Indigenous, Black, and other racialized communities, and launched a civilian survey to gather public views on street checks. In total, I met with over 2,200 people and received over 100 written submissions. It is important to note that street checks have not affected all members of the public in the same way or to the same degree. Numerous studies have shown that street checks have disproportionately impact members of Indigenous, Black, and other racialized communities. For instance, in the years 2010 and 2012, a series of articles in the Toronto Star highlighted the disproportionate number of Black people being carded. And by the year 2013, Black people were approximately 17 times more likely to be carded than white people in certain parts of downtown Toronto. Indigenous women are nearly 10 times more likely to be street checked by Edmonton police. According to 2015 reports, Black people in Brampton and Mississauga were 3 times more likely to be stopped by the police and formed 21% of all street checks, even though they were only 9% of the population. In addition to the consultations, I conducted in-depth Canadian and international research to address the myriad issues under consideration, and launched as well as conducted a civilian survey, which was a requirement under the terms of reference. Now, it's critical to any analysis of the issues surrounding street checks and Carden to ensure that we all have a clear understanding of what these terms mean. The two have been taken as the same, when in fact they are quite different. During the course of the review, it became apparent to me that there were many misunderstandings and misconceptions regarding the regulation, which I believe I must address. First, people are using the terms Carden and street checks interchangeably. They're debating the relative merits of those practices without a common understanding as to what those terms mean. I believe that there is a difference between what are called street checks and what has commonly been referred to as Carden. Police services use the term street checks to refer to any information obtained while an officer is out in the community obtaining information. For example, if an officer fills out an observation report that they saw someone doing something at a particular location, it is qualified as a street check, even though no identifying information was requested or obtained from that person. As a result, the first thing that had to be done was to define key terms. For the purpose of the report, a street check is limited to situations where identifying information is obtained by a police officer concerning an individual outside of a police station that is not part of an investigation. Carden is defined to be a situation in which a police officer randomly asks an individual to provide identifying information when there is no objectively suspicious activity. The individual is not suspected of any offense, and there's no reason to believe that the individual has any information about any offense. That information is then recorded and stored in a police intelligence database. Carden, therefore, is a small subset of street checks. I should also note that identifying information is not just a person's name. It includes any information which alone or in combination with other information can be used to identify an individual. This could be a person's name, but it could also be, for example, in combination their age, sexual orientation, marital status, socioeconomic circumstances, or employment history. I have recommended that this definition be standardized across the province. It is with these definitions in mind that I've conducted my analysis and review. I also thought it was important to provide the legal framework for the analysis. Police officers have a general duty to protect the public. They are provided only limited statutory common law powers to perform that duty. Police officers may ask people to identify themselves in any situation. Unless there is a legal requirement for people to identify themselves, such as when they're operating a motor vehicle, or they are under arrest, or there is some statutory requirement requiring them to identify themselves, people do not have to provide their identity to a police officer. The regulation attempts to ensure that if a person is asked by a police officer to provide identifying information when the person is not legally required to provide it, the request is made indiscriminately and not arbitrarily, and that the information is provided voluntarily. In that regard, the regulation simply codifies the existing common law. Now, when does the regulation apply? As I explained earlier, the regulation as it is currently drafted applies when a police officer requests an individual's identifying information where police are inquiring into suspicious conduct or a potential offense, or where they're gathering information for intelligence purposes. During these interactions, there's no obligation on the individual to provide identifying information, and they're at all times free to go. A point of concern is often raised, and I saw throughout my consultation, was that suspicious activities can be interpreted very broadly. What one person finds suspicious, another might not. And such a broad category could result in indiscriminate stops being made. For this reason, I have recommended that when police officers are requesting identifying information because they're inquiring into suspicious activities or general criminal activities, they must have objective and credible grounds to justify these inquiries. At this point, I'd ask you to please read the actual report. We've got copies in this room for all of you, and I think it's, you can't really understand any of these recommendations without understanding the context. The context is important. And I think it's the lack of context that has caused all this confusion and has caused us to be in the state that we're in. So I really encourage you to not just listen to my commentaries today, not just read the various newspaper articles, but please read the entirety of the report. I think it's critically important for all of us so that we're all aware of what our obligations are as citizens and what our civil liberties are. Now, for this reason, I've recommended, as I've indicated, that when police officers are requesting identifying information, because they're inquiring into suspicious activities or general criminal activities, they must have objective and credible grounds to justify these inquiries. And objective and credible grounds are defined in the report. I've also listed scenarios and examples in the report so that it can be easily understood by police officers as well as citizens, so that there shouldn't be much confusion in these kinds of situations. Now, in order to maintain public trust and confidence in police and to make sure police resources are used appropriately, stops must be based on more than a hunch or spidey sense. It is critically important that police officers be able to articulate their objective and credible reasons for the request. There are a number of circumstances in which the regulation does not apply, and I would like to highlight a few. The regulation does not apply to community interactions. Police should be able to meet and speak to members of their community without entering this information into a police database, without being obligated to follow the rules of the regulation. Conversely, community members should feel that they can meet their local police officers in casual, friendly settings and not feel as though their name is being requested to be recorded in a police database. The regulation also does not apply to investigations generally. The police are able to question potential witnesses and suspects in relation to an offense that has been or will be committed without following the rules of the regulation. And this is the law, by the way. They can also investigatively detain an individual that they suspect has committed an offense and can arrest an individual where there are reasonable and probable grounds to believe they have committed an offense or under some other lawful authority. Another important aspect of the regulation is the circumstances under which it prohibits the collection of identifying information. Police officers cannot collect identifying information if any part of the reason for the attempted collection is because the officer perceives the individual to be of a racialized group, or if the attempted collection is done in an arbitrary way. Of course, the one important exception to this is where racial identity is part of a subject's description. Where there is a description of a particular individual that police are seeking, and the police officer has a reasonable, specific description of the individual that consists of more than just that individual's age, gender, and racial identity, an officer can consider race in requesting identifying information. While ensuring that people are not stopped on the basis of race alone is an important step towards ensuring fairness and equality in police-public interactions, I do not believe it goes far enough. Stops should also not be made on the basis of other prohibited grounds of discrimination under the Human Rights Code or based on an individual's socioeconomic status. Such a rule would go a long way in developing trust between the police and the public they serve. Finally, it is not only interactions where an officer requests identifying information that must be conducted without bias and discrimination. All police public interactions must be carried out in this manner. Officers should be trained that they should have articulable reasons for their stops, and that no part of these reasons should be based on a prohibited ground of discrimination under the Human Rights Code. Of the types of interactions to which the regulation applies, it is the general intelligence gathering category that has drawn the most criticism from stakeholders. They view the intelligence gathering provision as a catch-all, allowing police to ask whomever they wish for their identifying information. Now, there are two types of requests for identifying information for intelligence gathering purposes. Specific intelligence gathering, where an officer has objective and credible reasons to believe that obtaining the identifying information would provide valuable intelligence, and random intelligence gathering, where the sole focus of the request is to gather names and create a database of individuals. As I've outlined in my report, the former is an appropriate police activity and should be a regulated stop. The latter, which essentially amounts to carding, is a different story. In order to determine the appropriateness of this activity, I asked two questions that were critical to my review. Do random street checks actually work? And should random street checks or carding ever be allowed? It is impossible to complete an analysis of this issue and not address the elephant in the room. And some people have made a connection between a significant decrease in street checks and an increase in violent crime. The link is, in my view, unsubstantiated. Many jurisdictions in Ontario did not report any increase in crime after reduction of street checks. In Toronto, violent crime actually declined in the years leading up to 2014, despite the fact that the Toronto Police Service voluntarily curtailed the number of street checks performed during this time, or the number of what I would say carded. As well, the 2016 to 2018 numbers, or as well, from 2016 to 2018, the number of shootings actually dropped in neighborhoods that had been heavily carded prior to the regulation coming into force. Gun violence is not the only indicator of violent crime, and I'm not in any way excusing gun violence. Like I said, I spent my entire career in the criminal system, and both as a prosecutor, as a defense lawyer, a trial judge, and a court of appeal judge. But we have to look at the objective data. Significantly, Statistics Canada has reported that in 2017, the first year that the regulation was in force, Ontario had the second largest decline in homicides among the provinces in Canada, which was largely attributed to guns and gangs. I think this is important to emphasize. The year the regulation came out, homicides in Ontario actually went down. The link between violence and street checks is also a spurious one because it compares apples to oranges. The general argument is that street checks have drastically declined post-regulation, and therefore any increase in violence is linked to that decrease. And again, the definition, of course, when these articles or when these arguments are being made, it still mixes in what I would say carding and proper street checks, right? So there is not that distinction. So the argument goes on, right, that there's this straight line correlation. This ignores the fact that prior to the regulation, police used the term street checks as an umbrella term that included many interactions that are not regulated and not considered street checks under the new regime. Before the regulation, street checks could include, as I've indicated, observations an officer made without talking to people, or information obtained in speaking to someone, not including identifying information. A reduction in the number of interactions that qualify as street checks would not impact the crime rate. Now, further, police powers have not been eroded. Police remain entitled to stop and question people reasonably suspected of being implicated in an offense without triggering the regulation. Police remain entitled to approach people and question them without asking for identifying information without triggering the regulation. Police are entitled to search people for weapons where they reasonably suspect that the person is carrying a weapon in a regulated or a non-regulated interaction. None of these important police powers have been taken away or impacted by the regulation. The only thing that has changed is that when a police officer requests a person's identifying information with less than reasonable suspicion of criminal activity, there has to be a good justifiable reason for the request. This, in my view, is not a difficult requirement. Now, it was clear to me from my consultations and research that the practice of random carding disproportionately impacts innocent, law-abiding, Indigenous, Black, and other racialized people. The long-term impact of randomly carding people in these communities is the alienation of entire communities from the police and a resulting lack of public trust in and cooperation with the police. Our current system of policing, as I've indicated, is by consent. The public consents to allow police officers to have powers and legal defenses unavailable to other citizens. A requirement of that consent is that police officers exercise those powers appropriately. Properly conducted street checks are an effective and necessary component of proactive policing. Most people support police in stopping people and asking them to identify themselves in the right situations. That is one of the areas of common ground that I identified in this review. For example, imagine that a police officer sees someone trying to open the windows of a home late at night. It is possible the person accidentally locked themselves out of their own home. It is also possible that the person is a burglar. If you agree that the police officer should inquire as to which one of those possibilities apply, and in my view, any reasonable person would, then you have just supported a police street check. Most people do not support the police randomly demanding that people provide their identifying information and then recording that information in a police database. As I will mention later, that has now become an area of common ground with most police services as well. The problem worsened in the past when police services made it a performance measure for police officers to obtain identifying information from people. That provided an incentive for police officers to engage in extremely poor police practices. The bar for what was considered to be suspicious behavior was lowered and then removed entirely. People were no longer stopped because they were acting suspiciously. They were stopped because they were available on the street to be stopped. In order to meet the required quotas, groups of young people sometimes were collectively asked by police officers to provide their identifying information. Some people were stopped on their way both to and from school or work and asked to provide their identifying information. The process sank so low that police officers, and I say some, and I would not in any, I'm not tainting all police officers, but some police officers began to record names and birth dates off headstones and cemeteries and submit it as street check data. Sometimes people provided someone else's name or address, presumably someone they did not like. So as a result, the quality and the reliability of the collected information was extremely poor. An analysis of collected street check data would indicate the combined presence of the walking dead. Police stakeholders confirmed that random carding produced low-quality intelligence. However, people were still denied jobs and other opportunities because of that data, some of which was incorrect information. Many newspaper reports indicated that certain groups were stopped and questioned far more often than others. Street checks were seen to be a manifestation of racial profiling. This resulted in a loss of trust and a reduction in the perceived legitimacy of police activities within those groups. It also delegitimized proper police street checks. Because of the negative publicity and the poor level of quality of intelligence, most police services stopped the practice of randomly stopping people and recording their identifying information long before the regulation came into effect. At the same time, through my research and consultations, I found that random carding had a very minimal role in detecting or deterring offenders or reducing crime. In my view, it is far better to use our limited resources to focus on individuals who are reasonably suspected of committing an offense, rather than use invaluable manpower to question thousands of people not reasonably suspected of anything. The negative impact of random carding, particularly on Indigenous, Black, and other racialized communities, combined with the limited evidence that it is an effective police tool, brings me to only one logical conclusion, and that is that random carding should end. Now, in my extensive analysis, I was unable to find an example of a situation where police's inability to randomly stop people to conduct street checks for general intelligence gathering, or as I've referred to it today, inability to randomly card people, would interfere with their ability to effectively fulfill their duties. Even in emergency situations or where they're faced with threats to public safety, the tools already at the police's disposal are more than sufficient to address any threat that may arise. Again, I'm going to point you to Chapter 4 of my report, where I talk about the legal framework. Chapter 5 and 6, I've given you concrete examples and scenarios for you to study and to look at. Many police services have already come to this same conclusion and have ceased the practice of random carding. For those services that have not, in my view, it is time. Now, a key part of my report focuses on the duties of police officers relating to the collection of identifying information and the standardization of receipts, forms, policies, and procedures for the implementation of the regulation. In noting the significance of civility and professionalism in officer requests for identifying information, I make a series of recommendations in my report on what must be included in the rights notification that officers provide before questioning or requesting identifying information, the tone and manner that officers should use when notifying people of their rights, and finally, officer requests for support and documentation. Now, recognizing the vulnerability of children and the lived experience that in many instances a street check is a child's, in some communities, first interaction with the police, I paid close attention to requests for identifying information involving children under the age of 12. I make a recommendation about when officers can request identifying information from children and the special rules that apply in these situations. This brings me to the concept of standardization and its importance. Standardization of documentation, policies, and procedures ensures that members of police services at all levels working across the province under expectations and understand the expectations and undertake their work in a systemic fashion. Standardization also ensures that members of the public know and appreciate under what circumstances and exactly when and how requests for identifying information will be undertaken. It also helps police officers who transfer laterally between services so that they all have the same level of training and they all have the same expectations. As it relates to requests for identifying information, standardization means, A, that officers must inform anyone they ask for identifying information that their participation is voluntary, that the receipt or the document of interaction provided to individuals after identifying information is requested or collected be the same throughout the province in content and format, so that citizens are confident that the same rules are being applied consistently. That officers must provide the reason for collecting and identifying information, as the reason is vitally important to provide clarity to members of the public on why they stopped or why they were stopped and asked for their identifying information in the first place. and that officers must record specific information during a regulated interaction in a form that is consistent for all police services province-wide. Having said that, it's also our recommendation that this form and this process be simplified. Now, consistency in standardization is also of great importance at an organizational and systemic level. By this I mean that there should be a minimum consistent province-wide policy to implement the regulation that is binding on all police services boards, which they can then adopt to include increased requirements if they so choose. Chiefs of police must develop procedures that are consistent with the policies developed by police services boards. Procedures should be binding on the chiefs of police. A template annual report should be developed for use by police services across Ontario, so that their reports, data, and analysis are easily comparable to one another. Annual reports should be made publicly available within the first 6 months of the following calendar year. Age groups and racial groups of those requested to provide identifying information should be standardized throughout the province of specific age, through the provision of specific age ranges and racial categories. Disproportionate impact should be defined to ensure consistency. Analyzed, de-identified data should be made publicly available for research purposes. Now, in my many consultations and through my research and analysis, I realized that consistency and standardization are only possible if there are monitoring, compliance, and accountability mechanisms in place. To this end, I recommend that collected identifying information be monitored to ensure it was properly obtained, and that an early warning system be set up to ensure that officers are following the regulation. Officers who are not complying with the regulation should receive instructions and retraining, and those who persist in breaching the regulation should be subjected to discipline. Now, I will turn to the importance of training and education. As I note in the report, a central piece of the review relates to the training provided to police officers on the regulation. Training is arguably the most important part of the regulation. In the report, I look at the training that was delivered in the fall of 2016 before the coming into force of the regulation, and then discuss training on an ongoing basis. The training offered in the fall of 2016 generally complied with the requirements in the regulation, but was lacking in certain regards. First, the training failed to give enough attention to the reason for the regulation, and as such failed to get strong buy-in from officers who viewed it as a Toronto-centric problem. Second, the training failed to spend enough time on the regulation itself and the legal bases and authorities for police stops. Third, there was no specific training for data verifiers, supervisors, or for chiefs of police on their specific roles and responsibilities under the regulation. Recognizing these issues, I make specific recommendations in the report to expand the scope of the training and ensure consistency throughout the province on a go-forward basis. I highlight the importance of police-community collaboration in the development and delivery of training to police officers, and that any future training include a focus on adolescent development, the local realities of the police service in question, the application of the regulation for real-world scenarios, and a general focus on the ability to articulate reasons. The training should include testing, and there should be regular periodic refresher training. Additionally, I recommend that Ontario consider establishing a college of policing as the professional body of policing. I introduced this recommendation in my report of the Independent Police Oversight Review and underscore it here again because it bears repeating. Policing is a demanding, complex profession, and a degree program of expanded educational requirement would go a long way to ensuring that police officers have the full suite of tools to undertake their important work. Equally important to the education and training of police is public education and information on the regulation. Members of the public have not been properly and fully informed about the regulation and its operation, and this has resulted in mass confusion and misinformation about street checks, carding, and the rules within the new regulation. The public must not be trained simply on the regulation and its operation, but also about key legal principles and authorities around concepts such as, police authorities and the right to walk away freely, and as well as the whole legal concept of investigative detention. I recommend that any public education and training materials be developed using a multifaceted, multidisciplinary approach, which involves community groups, legal aid clinics, school boards, and youth advocacy groups. There should also be a full cross-platform advertising social media strategy on the regulation. During my consultations throughout Ontario, I also noted that there was a need for a robust rights education program. And, I note at this point that civic education is no longer taught in our schools at the levels that we were taught at when I was young. And I certainly believe that this should be a part of educational curriculum. In addition, individuals should be taught about indigenous histories and Black history and information as to how their experiences historically has affected them living within this cultural mosaic. Now, another key issue is the retention of identifying information in the database. Information collected during regulated interactions is often stored in a database within the police services records management system. The storage of this collected information raises many issues that warranted my close attention. Many stakeholders indicated that the data was critical to solve future crimes and to answer any potential future complaints or lawsuits. Other stakeholders pointed to many high-profile stories of how the information stored within these databases has had a negative impact on the lives of many law-abiding citizens. Some of these stories are outlined in the report and include instances where the data collected from street checks stored in databases resulted in the loss of employment and educational opportunities. A range of reports and studies have recommended different timeframes for the retention of identifying information in databases. I recognize that it was imperative to set a definitive time limit across the province for the retention of identifying information, after which time it should be destroyed. I determined that 5 years was an appropriate period. Historical data, meanwhile, refers to data collected before the coming into force of the regulation, to which the regulation would have applied had it been in place at the time. Recognizing the importance of consistency in the management and handling of data by police services province-wide, I recommend that historical data should automatically be destroyed 5 years after it was collected. Now, finally, the terms of reference ask me to consider any overarching changes to improve the implementation of the regulation. and I recognize at the outset that any review of the regulation would be incomplete unless I pursued a contextual approach that considered themes of public trust and confidence in policing. In my report, I've considered some ways in which street checks intersect with police practice more generally, and made some observations and recommendations in the areas of community policing, partnerships with Indigenous communities, locally based policing, and diversity and inclusion in police services. Community policing is instrumental in establishing and maintaining strong police relations and building public trust. Partnerships between police and Indigenous communities developed through strong programs and initiatives build on recommendations made in previous reports and are crucial to establishing meaningful, equitable relationships with Indigenous communities. As for locally based policing, there was a concern that arose repeatedly throughout my consultations, that many police officers often did not live in the communities they served. This distance resulted in a lack of strong direct links to the community or knowledge of the community. As such, I've recommended that police services make efforts to hire people from within the city or region of the services that the police officers will be serving in, and that community police officers in particular be engaged in a local community for a sufficient period of time to form positive, long-lasting relationships. Last but certainly not least, I underscore the importance of diversity and inclusion in police services. Part of the perception of discrimination in regulated interactions or street checks may result from the fact that the police officer requesting identifying information is from a different racial background than the person from whom the information is sought. I believe that a diverse, inclusive police service at all levels is essential to address this concern and make a valuable difference. To this end, I outlined the importance of periodic data collection and diversity and inclusion strategies. Now, in conclusion, I'm grateful for the opportunity to provide my input into this important area through this report. I cannot in one brief speech properly cover everything detailed in the report. I hope today has given you an area or an idea of the work that I've done on this review. But I also ask that you take the time to read and contemplate the report in its entirety. I believe that the recommendations I have made will improve public confidence in policing and bring much clarity to the complexities and confusion in the regulation. In my work reviewing the regulation, I have seen firsthand a great commitment by members of the public, police, and community organizations to make meaningful changes to ensure that there's an appropriate balance between principles of public safety and the protection of human rights. I want to close by acknowledging and thanking all of the stakeholders we met with during our consultations in Ontario. I could not have undertaken this work without your contributions. Thank you very much. That is my presentation. Thank you. I will now excuse myself, and I have my counsel here, just so that you're aware. As a judge, I don't answer questions on my judgments, and I'm not going to start a new precedent in answering questions on this report. I'm encouraging all of you to read the report. Thank you.
Thank you to Justice Tulloch. I'd now like to call up our review counsel, Prasanna Ranganathan, Jacqueline McNamara, and Christine Mainville. Pour les journalistes et participants francophones, veuillez noter que Christine peut répondre.
For the English-speaking journalist, Ms. Mainville can answer your questions in French.
Dave, if you could just wave, and Esther have microphones. If you have a question, please make your way to them or signal to them, and they'll bring the microphone to you. Please also note that counsel is not available to answer questions about individual or personal cases. We've got 30 minutes set aside for questions, so I'm going to ask that you keep your questions brief so that we can hear from as many people as possible.
Could you just clarify counsel's role? Do they represent Justice Tulloch?
Yes, so they were the counsel to the reviewer. We've got a small team, and they're lawyers, yes. So these are our 3 lawyers, and they're available to answer questions. So if you have a question, just raise your hand, and Dave will bring, or Esther will bring you a microphone.
Thank you.
Yeah.
Thank you for being here. I just have a question related to Justice Tulloch's definition of street checks versus carding. He gave an example of a street check, which was somebody opening a window and police stopping and investigating that. I want to know, does that street check definition, is it synonymous with the practice of investigative detention? And can they be used interchangeably?
Did you want to repeat it?
Sorry, just a point of clarification. Are you asking about the example Justice Tulloch provided in his speech just now?
Yes, I am.
Okay. So in that instance, Justice Tulloch was outlining the context of when street checks would operate as opposed to carding. And the example that we'd like to point you to, I think that would clarify that even further, is the one in chapters 5 and chapter 6 of the report. And that has 4 scenarios. And that clearly outlines the distinction between street checks and carding, street checks, and also then the notion of investigative detention. Thank you.
The report is highly commendable in dealing with situations wherein police officers stop, arbitrarily detain, hassle, some may say, individuals, and attempt to get identifying information. Why is the report silent as to the most common form of street check today, which is stopping individuals who are minding their own business, asking them all sorts of random questions without identifying, requesting any identifying information, therefore falling outside the regulation? If I'm right in that, the amount of street checks that the Toronto Star covered is going to continue, and we're not even going to have the data to support whether or not it's racially motivated. Thank you.
I think that's it's a fair concern. It's I think one of the central ills and that the regulation was initially targeted at was the fact that at the end of the day, people's information, personal information, identifying information was collected in a database which had significant or could have significant repercussions for members of the community. And that is on a long-term basis. And that is really one of the principal ills that was targeted to at least be able to curb that. And that's why there is a significant focus on the collection of identifying information, because that's really, at the end of the day, what has potential long-term consequences. It's a bit more of a difficult issue to regulate various interactions where no information is collected. But there are recommendations in the report that seeks to address these concerns and educate both officers and the public about the types of interactions that should be taking place, civility and and basic core principles that should be respected by police officers in all instances, and emphasizing that identifying information should be requested only at the end of the day when necessary, and even if there is a circumstance where the police should be interacting with individuals or approaching them because of there may be a situation of concern, that the starting point should not be to request their identifying information. And so there is no ban on approaching civilians in various instances, nor should there be necessarily. It shouldn't be abused of, and I think the report makes that clear.
And I would also add to my colleagues' comments is that the purpose of the review is specifically to look at the terms of Regulation 5816. And that regulation was designed around the issue of asking for identifying information. So the analysis centers on that approach, and that is also the parameters within which we provided the analysis.
All right. Hi there. Sorry. Oh, okay. Hi. So one of my questions is towards one of the Justice Tulloch's recommendations in the report. So one of his recommendations asked that if a child who is 12 and under, they should not be street checked unless a parent is involved or they get permission from the parent. Now my question is, from my experiences, I know of many individuals who are 13 and 14 who have faced traumatizing experiences when they were randomly stopped. So don't you think 12 is too low of a threshold? Because 13, 14, for example, those kids can be traumatized and they can impact their life, and a lot of them need counseling after they face experience, and then they lose a lot of trust with policing. Thank you.
Thank you for that. I think I do have to address one of the core premises of your question, which is that these youth are being randomly stopped. And Justice Tulloch is very clear that random stops of adults, youth, people under the age of 12, over the age of 12, doesn't matter, those should not be happening. And so the situation about a parent or a guardian needing to be present is aimed at not carding situations, but other types of interactions where the police may wish to request, for valid reasons, a person's identifying information. And what Justice Tulloch recommends is that that should not happen when a person is under 12, unless a parent or guardian is readily available and present for it.
I would just add to my colleague's response that the recommendations that Justice Tulloch has made reflect the existing framework in the Youth Criminal Justice Act and the ages that are set out in that act. And so rather than imposing a new age limit and determining that separately, he's gone with what is the existing criminal law.
Hi, thanks so much. Justice Tulloch acknowledges that policing is a demanding and complex profession. He said that here today. And also, we know that police officers often have to make life or death decisions and think very quickly on their feet. In saying that, he says, stopping someone for suspicious activities can be interpreted very broadly. That idea of what is a suspicious activity, it must be objective and credible and can't be based on spidey sense or just a hunch. How confident is the justice that, there's a lot of recommendations here that an officer will be able to, when he sees someone and has concerns, be able to, quickly go through the criteria in his mind, or his or her mind, for example, and make sure that, they're not infringing on someone's human rights, that they are respecting the recommendations if they are approved by the Ontario government. I mean, how confident is he, a police officer, to think quickly and do that, follow the regulations?
I'm very confident in their ability to do that, because that's what police officers do on a daily basis. That is what they're trained to do. The criminal law is replete with various rules, parameters, standards. It's what they do regularly. And I think part of the issue with the current framework, or up to now, that Justice Tulloch is trying to improve on, is that there were legitimate reasons to be confused about some of these thresholds, the standards, the parameters. It's the regulation was confusing in many respects. And so it's true that there has been difficulty in applying it, and quite legitimately so, because even lawyers would have difficulty sometimes understanding certain aspects of the regulation as currently drafted. But our hope is that once, if and when these recommendations are implemented, they actually simplify, clarify many aspects of this regulation. And having done that, I'm quite confident that police officers would be able to distinguish between what's a random or inappropriate discriminatory stop and what is objectively grounded and warranted in terms of an interaction and a potential request for information, identifying information.
And to just add a point here, Chapter 9 of the report specifically talks about the parameters of the training that should be delivered. It includes a review of the training that was provided, and the report clarifies the confusion that had existed previously, held by both members of the police and the community, just widespread confusion. And so Chapter 9 talks about how that training should happen on a go-forward basis, and how both community members, members of the public, and the police should be trained so that there's a common understanding.
Good morning. I'm from the African Heritage Educators Network, and I have to commend the judge for actually making it a point to state that the recommendations should be part of the curriculum for our students. Now, having said so, I'm wondering further what action plans are recommended and what sort of accountability measures are in place for that to happen. Because many of, as my brother just said, many of the victims of carding, many of them have been very innocent and vulnerable kids. And many of them have been led to the path where they ended up being so harassed that they actually went into paths. They were placed in and pressured so much that at some point, you know, when you're hunting, you're going to find something, right? So they were targeted. So, you know, for the protection of our kids, I'm just wondering about measures, action plans, accountability measures for that are placed for the protection of our kids. Thank you.
So just as a starting point to address your question, we want to acknowledge that this is a really traumatic issue, and we had so many people come out to consultations and come to private meetings with Justice Tulloch and share those traumatic stories. And all of those voices have been heard. The report could not have been drafted as it was without your contributions, and so I know Justice Tulloch really appreciates that, and so do we. With respect to the specific content of your question, action plans and how to proceed with public education, Justice Tulloch has made a number of recommendations with respect to how he believes that should proceed, including cross-media advertising campaigns indicating various aspects of both the regulation and existing laws surrounding police-public interactions. But with respect to a specific action plan going forward, Justice Tulloch's mandate was to produce this report, and it's now in the government's hands. We have every confidence that they're going to move forward in good faith, but ultimately it's up to them to decide.
And he asked about discipline measures.
Ultimately, it's up to them to decide how to proceed with the recommendations. With respect to discipline measures, that's in Chapter 11, specific recommendations regarding how officer discipline should proceed.
And I would just add to my colleagues' comments that Justice Tulloch has designed the recommendations so that they are a step-by-step process. Like for education particularly, he references the importance of youth education in Chapter 12. He talks about public education on the regulation in Chapter 9, and all of them talk about various models of doing so. So social media campaign, as my colleague mentioned, also revising school curriculum in Chapter 12 with reference to models that are existing on rights and responsibilities education throughout the country so that young people are aware of not only the regulation, but also their rights sort of more largely within society and within like the context of the criminal justice system.
Good afternoon. Two interrelated questions. First, the rights notification component of the regulation is one of the central, I think we would agree, components for police accountability in terms of police telling people whether or not they have the right to walk away from an interaction. My question first is, have police in Ontario been notifying civilians during stops that they have the right not to answer questions, that they have the right to walk away, and how have you verified that they're doing that? And secondly, related to Howard Morton's question about stops where police do not end up collecting information, is there a requirement for rights notification in those cases also? So if the police are like, well, I didn't end up taking your information, what triggers the police's necessity to tell us what our rights are? If they're just like, hi, Desmond, how are you today? We could argue, I guess, that they don't have to tell me my rights. But then if they don't have to tell me then, what forces them to have to tell me in a given situation that I am free to go, that I don't have to answer their questions?
So, sorry, I'm having a bit trouble seeing with the lights. I apologize. So for your two questions, the first I would say is that Justice Tulloch met with representatives of, as he notes in the report, 34 police services in the province of Ontario. And during those meetings, there were very in-depth questions about the numbers of regulated interactions that had happened since the regulation. He also made it a point to not just meet with senior leadership in the police services, but also meet with frontline officers, middle managers, sergeants, supervisors, everyone, because he wanted to get a sense of how this regulation operated in practice. When it came in, who was responsible to verify the information, what they had to do. Like, he went in minute detail with each of these services. In terms of the reporting on the regulated interactions, we had two frameworks by which to analyze it. One was the annual reports that were released by the police services to the police service boards. And then the second was speaking with representatives at the OIPRD to determine if there were public complaints made under the regulation in terms of conduct that had existed there. He also asked officers that he met with throughout all of the various services about whether they had undertaken this work, what were the complexities, etc. The same sort of rigor was applied in both the public consultations and private stakeholder meetings to get a sense of if what we were hearing from our meetings at the police services, what we were reading in reports, was reflected in community experiences. And so we heard from the full spectrum of participants in order to make that determination. One of the challenges of the report notes is that only 13 police services had provided annual reports at the time of writing. And those annual reports are required to show the number of regulated interactions that happened throughout the year, as well as the disproportionate impact, if any, existed, and the groups, the individuals under those stops and what racialized communities they belong to. So that was mandated under the regulation, and that's what some of the reports provided. As Justice Tulloch notes in Chapter 10 on the reports, he talks about how the report needs to be standardized, because sometimes you would get a 20-page standalone report, and at other times it would be 1 to 2 pages in another, like, minutes of the meeting. So there is a real need for standardization. His belief is that with standardization, there's a requirement then for objective and clear reporting throughout. And if that reporting is consistent across services, then it's comparable as well to see, has this regulation made a tangible impact, and have there been changes?
I guess just my simple question is, when you ask police officers and police chiefs, are your officers providing rights notification, what did they say?
They said, well, no, but I think in the generally speaking, and without being able to report at this moment every conversation, I think there was compliance generally.
Yes, we were hearing.
When the regulation applied, we did hear that there was confusion sometimes in terms of when the regulation applied. That's what we hope to improve on. And in terms, I want to answer certain aspects of your earlier question as well. In terms of a built-in protection for ensuring that this is done, there are several of them, but a key one is that the information obtained cannot be placed into an accessible police database unless all of the regulations requirements have been followed, including notification given. And there's a system in place, or there has to be a system in place, and there are verifications of the information done, and there's verifications of that system to ensure that that is being done. And so at a minimum, the information won't be able to be accessed and used if those requirements are not met. Now, to your point about when information or identifying information is not ultimately requested, I can't say much more than my earlier answer, other than the hope is that I think the only real thing that could truly address that is public education, so people know that they don't have an obligation to speak to the police, except in certain circumstances, if they're detained or arrested, of course, or pursuant to certain lawful authorities, certain legislation, like if you're driving a vehicle, right? But in other instances, the hope is that there will be enhanced public education so that people know and understand their rights and that they have the right to walk away generally.
Good morning, or afternoon now. I want to say thanks to Justice Tulloch and his team for this report, because being part of PACER that has vested over 6 years, and we still have some subcommittee members who are still within the loop of following through. He's touched on some very key issues. For me, though, that was very clear a little while ago, is the 5 years that he has recommended for the retention of information based on cases that are either current or for appeals. But when we brought up back in 2014 the aspect of all the data that has still been sitting on individuals that are not being used for any of those two parameters, when are we going to finally destroy the documentation? And that has to be clear, that we're putting it there, that if it is not for current cases or for any appeals that are going forward or any lawsuits, all of that data, the hundreds of thousands of data that's been collected on individuals, should be expunged, should be removed, whichever terminology wants to be utilized. We have to push for this. And then the question then becomes, this report is going to the Ministry of Corrections and Safety, but do they have the final say with regards to the direction to the various police forces to say destroy or expunge? Or is it still, as you just stated, is it still at the discretion of the chiefs to be able to make that determination of that data that has been collected within their databases?
So your question is with respect to what the current state is, or what Justice Tulloch's recommendations have been? Because that's... Right.
This recommendation, how do we try to ensure we expedite that all of that data, or to whom is accountable for making sure it is destroyed?
I would say two things. The ministry can direct and can choose to adopt the recommendation and direct all police services to do that. That's in their hands. Police services have a certain discretion to destroy data subject to certain laws that may require them to preserve certain pieces of information, but they would have some discretion in that respect. And I would also just point out that pursuant to the regulation as it currently stands, data that has been collected prior to 2017, and identifying information, I should say, that's been collected prior to 2017, and that would fall within the application of the regulation, is in a restricted database already, and that's been verified. And so only subject to those exceptions that you've cited. Is that fair? Okay.
Thank you very much for all the work you've done on this. I was present in Scarborough in one of the consultation meetings. I came from it from the point of view of the effect on employability, as I currently am on secondment with a union. So the workers of color were very concerned about the impact on employability. Question, can you connect the dots to me? Because that was raised in the consultation, that some people had experienced prejudice to their current work or loss of employment. Justice Tulloch spoke about that today. So I'm pleased that he heard the message was made loud and clear. But can you just expand on how does that take place? Because in my way of thinking, if I'm required to do a police background check for employability, if I have a record, that comes up. But how could a street check result in loss of employability? I've not been able to demystify that.
I think it's largely in law enforcement, and so if someone applies to the police, it would typically or generally, as we heard, be a bar to being employed by law enforcement. And there is new legislation that's come into effect generally about provincial law that's come into effect restricting non-conviction records from being a bar or to employment and being disclosed even by police services. So prior to that, now it could not be, just based on that law as well. It could not be a bar to other types of employment. Prior to that, it might have been a bit ambiguous about when that information could be released. But certainly the main impact we've heard of was when people were applying to the police or other law enforcement bodies, who had that information, of course, because it was accessible to them.
And in chapters 2, particularly, we talk about the impact that had pre-regulation. And in chapter 11, the recommendation that Christine shared is specifically there about how regulated information, data from regulated interactions, as well as historical data, cannot be used in any sort of pre-employment screening, vulnerable sector check, any of those things. So that's specifically a recommendation in chapter 11.
Esther? Yeah.
Hi there. First of all, just wanted to thank Justice Tulloch and the staff for your work and for the recommendations. I have a couple questions, and they are related. The first is, you keep using the word "the ministry can choose." So if the government chooses to do nothing, and let's be frank about what we're talking about here, the Premier, whenever asked about carding, has deferred to the language of law and order, and doesn't seem to have an interest in exploring this issue any further. So if the government chooses to do nothing, what happens then? And my second question is, in the absence of the government taking action, what concerns me is the data, not just because of possible loss of opportunities, but also because of people who have, say, for example, had their security clearances stripped away and have lost their jobs due to information that was stored in the database. So in the absence of the government choosing to take action, the data that's already there, to what extent can people challenge the police service's right to retain that information?
I think Justice Tulloch has completed his mandate that's been asked of him. That's the extent of his authority on this issue. Frankly, it's in the public's hands, and it's in the government's hands. But we trust that this will be looked at seriously, and we hope that I think people see that there is common ground here, and if the report is read fully and understood properly by all, the hope is that there should be little disagreement, frankly, about why it should be implemented. So, but was it not the same? I'm not sure I understood your question, that what can be done if the government doesn't act?
If they do nothing, to what extent can people who have information stored in the databases, to what extent can they challenge the police service's right to retain that data?
Oh, I see what. For before the regulation was into effect, before 2017? Do you, or no, generally?
We can provide that.
Yeah. I think, yes, I think it's, I think I'd be providing you with direct legal advice if I were to, to do that. So I don't think I can answer the question generally.
Fantastic.
Kingsley Gilliam from the Black Action Defense Committee. And I want to congratulate Justice Tulloch and the exhaustive piece of work that he has done with this very nebulous subject. He has vetted and clarified what is actually going on and made some outstanding recommendations. The problem we have is that the current government shelved Bill 175 hours before by notifying the police unions only, not the public, not any stakeholders. And so this is in their hands at this time. Justice Tulloch has met his requirement by virtue of his order in council. And it's going to be up to each and every one of us in this room to make sure that Doug Ford does not file it in 513. Having thus said, I just want to address a couple of questions, issue relating to the concept of training of police. Because it is a common understanding that training is the panacea for every ill.
Sorry, Kingsley, can I just ask you to just get to the question?
I'm getting there.
Thank you.
Now, what really happens is that around the training, Justice Tulloch has mentioned a number of different types of training that should be included. But it does not address training to deal with the core problem, which is racism, anti-black racism, and racial profiling. So, the training package should include mandatory training on anti-bias and anti-black racism, anti-racism training. It's not only anti-black, but there's racism towards various groups. So anti-racism training. Without that, you are not going to get someone who has that bias to change. It is a structured type of program, and I know about that because I designed and delivered that in the OPS before.
Great. Okay.
Yeah. Thank you for your question. I will again just say that Chapter 9 specifically outlines how anti-bias training and training about anti-racism is essential. And it actually, Justice Tulloch very powerfully notes the importance of the police working with communities to jointly deliver that training, to help them design the training, to talk about local realities. Justice Tulloch underscores throughout that chapter not only about historical issues or systemic issues, but about how those issues play out in local communities. And so he's very insistent that the training have local realities threaded throughout it. And it's not just a one-time training as well. Justice Tulloch has underscored the importance of regular periodic refresher training that will include those elements. And so that's a really essential part of it.
And so, yes, just to be very clear, the recommendation is there for that type of training to be delivered. And I also want to be clear that it's not also about simply singling out police officers. It's a reality in our society as a whole. Yes, this is dealing with police, but I think more broadly than that, it has to be contended with more generally. And it's not simply overt racism. It's, as the report takes pains to explain, it's unconscious biases, which are sometimes contrary to the actual values that people say they hold, right? And so it is something that is difficult to contend with, but it's addressed directly in the report.
Thank you. I'm just going to say there's only time for 4 more questions. I know it's going a bit long, but if folks could just take their conversations outside instead of at the back of the room, that would be appreciated. Sorry, next question. Only 4 left.
Hi. So Justice Tulloch said that police officers should be able to articulate the reasons why they're stopping someone and taking their information and so on. Is that, are they supposed to articulate that in a report that they're making to the person they're speaking to, or is it just like a mental exercise?
So the police officers need to be able to articulate objective and credible reasons why they are requesting identifying information, both orally to the person that they are speaking to at the time, and Justice Tulloch has made the recommendation that those reasons should be recorded on the receipt that is given to the person, and that's a record of the interaction.
And not just a checkbox, but an actual detailed, precise description.
And the receipt also, the reason also needs to be, according to Justice Tulloch's recommendations, inputted into the system when it's being submitted. So that reason is in those orally on the receipt and on the form being submitted.
Thank you. My name is Miguel Avila, and I spoke at the Tropicana Community Center. I was one of the participants and asked a question regarding education towards residents of Toronto Community Housing. As you are aware, Toronto Community Housing signed with the Toronto Police Services an agreement to come into our homes and to our units and to anywhere they want to, because they are the agent of the landlord. So I brought this policy card into the Toronto Community Housing Board of Directors. I told them, listen, we have a new recommendations, new regulations on street carding because the matter is related to agent of the landlord. So you know what they told me? We're going to be taking your comment under advice, and it has been more than 2 years now. And when I went to Tropicana, I asked Judge Tulloch if he can make recommendations at the municipal level. So that is my question. If someone can answer that question, that would be wonderful, because the Toronto Community Housing has been, the object of human rights violations by Toronto Police in many, many ways. Thank you.
So thanks for your question. There are authorities, you're correct, under certain pieces of legislation, such as the Trespassing Act and the Highway Traffic Act, that grant officers certain powers and that fall outside of the scope of this regulation. Given the mandate given to Justice Tulloch, what he has done, because he heard concerns about these situations, he's conveyed these concerns and recommended that the province consider reviewing those pieces of legislation to see whether the similar protections could be built into those pieces of legislation.
I'm specifically speaking at TCAC, the Board of Directors, because I provided with the full document, and they have not done anything about it. The document is sitting somewhere, and they have done nothing. Thank you so much.
Thank you.
Thank you.
Hi. So I'm Raven Wings from Black Lives Matter Toronto, and what I've noticed is that it wasn't necessarily mentioned that the reason why we're sitting in this room is because of the death of unarmed black men at reasons of this sort of confusion that was articulated by Justice Tulloch. So I'm wondering, because he mentioned that there would be sort of what the consequence was to go back into training if they broke the regulation, if police officers broke the regulations that were being offered. What exactly is that? What is the actual consequence other than going back into retraining or along with?
So I think there's a few aspects to the consequences. The first being that if the information, as I mentioned earlier, the information can't be used if the check was conducted improperly. The second being that the verifications have to happen very promptly, and the minute it's seen that it was improperly done, the first step is retraining because there's been confusion, because sometimes it's in good faith that errors are made. But there's a clear recommendation that if the officer persists in making errors or conducting checks improperly, that discipline measures should be taken, disciplinary measures. So.
Sorry, so what are those disciplinary, or who decides what those disciplinary measures?
Do you have the chapter?
Yes, chapter 11.
I might refer you because it's an elaborate scheme. We'll refer you to the relevant chapter.
11,
Chapter 11,
starting at paragraph 61.
starting at paragraph 61, is the part of the chapter on that.
Will the work be considered?
Sorry, sir.
None of the recommendations are implemented.
There's-
After all this work, if no recommendation is implemented,
I think we've had that question.
will it be considered a waste of time? What are the
Sir, we've had that question already, and we've got one last question, and then we're going to conclude. But thank you.
Thank you. I had to step out before you guys started, so I do apologize if this was asked. But I was just curious because Justice Tulloch talked about the subset of the proper checks, the fact that there's obviously a need for proper checks, but the carding issue has turned into that small subset. So I'm just curious, and again, apologize if this was asked, but can you give kind of a quantitative, perhaps ratio of even just Toronto alone of how much of that percentage of proper checks, is it 5%, 10%, 15%, 20%, that would be considered a random, arbitrary, inappropriate carding example? Is there a
I frankly think that's impossible to give you simply because there was no kind of uniform definition of these concepts before. It was done in practice. We've kind of framed it to be meaningful, and so people know what is being discussed and debated. But it's not as though they were clearly defined, even as between different police services, or that they were compiled in any kind of clear, measurable way. So unfortunately, it was difficult to really tangibly.
And before we close, just to pick up on a theme Christine said, because I think it bears repeating and maybe to be underscored. As Justice Tulloch mentioned in his speech, the regulation is the first time any province in Ontario has looked at this issue through legislation. And so the purpose of the review is to review that regulation and see whether it was working in practice. And Justice Tulloch made recommendations in this report to make sure that there's clarity where there was confusion and to bring sort of a new path forward through this regulation. So I just wanted to add.
Thank you so much for that. And that concludes our question portion. Thank you so much for coming out today and for supporting the work of the review. And we appreciate all that you've done over the last 18 months to support this work. It would have been possible without you, and for that we are very grateful. Thank you.